Good morning, everybody. We ready to go?
Good morning.
We're ready here.
Morning, Ms. Cook. Morning, Ms. Costa.
Morning, Your Honor.
Good morning, Your Honor.
Very thankful for two of my favorite attorneys here today. It'll be a good morning. All right, we're gonna have Lazaro, Guerrero, and then Turner.
And this is Jimena Fini, Certified Court Interpreter Spanish, NVF XP 610. Tenemos entonces a Lázaro Guerrero.
And Your Honor, I don't know if we want to trail this due to the nature of the allegations.
No sé si quiere que sigamos esto debido a la naturaleza de los cargos.
Okay. Miss Interpreter, we don't have a long calendar, so it shouldn't take too long.
Okay, thank you.
Thank you.
Tome asiento. Siéntese.
We'll do Turner and then White.
Turner.
All right, what does the state feel appropriate on this matter?
Your Honor, based on her lower risk assessment score and no prior criminal history, the state is not going to oppose an owner cognizance release. We are asking for pretrial supervision with testing as a condition of that release.
All right. I'm going to set two court dates. Well, actually, one court date for you. Your arraignment is next 1 week from today, the 4th at 9:30. But I want you to check in with us by the end of Monday. So make sure we have good contact information, okay, for you. All right, we'll see you then. Obey all laws, make all court appearances. Our court will do the notices and the reminders.
Hold it, she's ready for
I'm ready.
our court date. Just wait.
White and then Burke.
Turner, just wait.
Yes.
All right, what does the state feels appropriate on the White?
Your Honor, state seeking $30,000 for Mr. White, along with pretrial supervision with testing for controlled substances. What we know about Mr. White is that he is on probation for a felony offense, a prohibited person in possession of a firearm. He was convicted of that offense in 2024 out of our Second Judicial District Court. In addition to that felony, he has 6 other prior felonies dating back to 2004, which revolve around drug possession. His last felony conviction prior to that was a possession of a controlled substance out of our Second Judicial District Court in 2019. He had multiple pretrial violations associated with that case, as well as a failure to appear. He has had another possession of a controlled substance felony in 2020 out of the 9th Judicial District Court, trafficking in 2014, and a dangerous drugs deliver methamphetamine and possession of methamphetamine out of Oregon back in 2005, and a theft felony out of Oregon in 2005 as well. So defendant continues to commit criminal conduct, obviously committing this offense while on probation for that serious felony. So the state believes that $30,000 is appropriate.
All right, sir, you said you were going to hire your own attorney. Is that still the case?
I'm not sure, sir.
All right, well, you can apply for the public defender if you'd like.
Okay.
All right, raise your right hand. Do you solemnly swear or affirm under penalty of perjury the evidence and testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Sure.
All right, tell me what your weekly income is.
I make about 1,500 a week.
How many people do you support on that?
4.
And do you receive any government assistance?
No.
I'll give you the public defender, or grant you, I should say, not giving. Ms. Cook?
Thank you, Your Honor. In regards to Mr. White's case, he is not able to afford the amount of bail that the state is requesting in his case. I do understand that he does have some criminal history and prior compliance issues. However, he does score a moderate risk on the MPRA. I know that pretrial services was able to verify all of his personal information, which our office was similarly able to verify his residence in North Reno, where he has lived since 2022. He lives there with his daughter and his significant other and her son. She indicated to us that he is welcome back in the home. As the court just heard, he does have full-time employment with Gearhart and Berry Construction, where he has worked for nearly a year. Prior to that, worked with Blue Kangaroo and A+ Tires. He did home restoration and cleanup with Blue Kangaroo and worked as a mechanic with A+ Tires. He has been in a relationship with his significant other for nearly 5 years. I believe that given his moderate score, that with appropriate supervision and conditions, although I don't know what additional would be necessary given that he is being supervised by probation, that an own recognizance release is appropriate in Mr. White's case.
All right, thank you. Good arguments on both sides. I think the most compelling argument is the fact that he is on probation and is being supervised, and that we don't have the ability to really do much more than that right now to minimize the risk that he poses. If he's, I am going to set bail. If he's reinstated on his PMP case, then reapply. If he's released and that hold's dropped, then I will grant a new hearing, and there's no motion that's necessary. I think that's a change of circumstances that would justify a new bail hearing in front of me. And then we can talk about how to minimize the risk if he is reinstated. But right now, given the circumstances, the state's shown by clear and convincing evidence that bail is necessary to ensure the safety of the community and appearance of the defendant will be set as requested. I'll order random drug and alcohol testing, daily mutual support group meetings until in treatment, and I want the DUI rant in the cars. And I think those two will also help inform us of the risk that he poses, because the MPRA is a general risk assessment that's not valid for the DUI population. We also need that CARS mental health screener so we can see what sort of other needs we have to mitigate for the safety of the community. There will be DAS supervision of bail laws may go court appearances December 5th at 9:30, the defendant's next court date. We'll see you then, sir.
Mhm.
Birch and then Graney. All right, what does the state feels, well, yeah, what's the state feels appropriate on this, man?
Your Honor, the state seeking $100,000 for Mr. Birch, along with pretrial supervision with a no contact order pursuant to statute as well as per condition of the case. We would ask for no firearms or weapons, along with a no alcohol and testing clause, as well as house arrest and GPS prior to release. State believes that bail and those conditions are supported by, number one, the facts of the case, which are extremely violent, 2 different episodes of strangulation or impeding the victim's ability to breathe, one of those being placing a plastic bag over her face. We know that the defendant scored a 5 on the risk assessment. However, he does have history. He was cited just this year for some traffic violations, including suspended or canceled registration out of Reno Municipal Court. The defendant did fail to appear at his arraignment in that case, and a bench warrant was issued back in April for his arrest. Looks like he was booked on that when he was arrested on this case. In 2024, he was arrested for domestic battery out of the Reno Municipal Court. That case revolved around the same victim. Victim had visible injuries in that case as well. Unfortunately, that case ended up being dismissed November of last year. He did test positive for opiates while he was on probation, or excuse me, on pretrial supervision. He blamed it on a bagel. Reno Municipal Court did increase his testing, and I don't see any other violations after that. We were able to speak to the victim, and I see that she is present here today. She is seeking that no contact order. She said that she is still hurting very badly from this incident, meaning her person. She has bruises on her arms, her left eye, her arms, her neck is sore, her throat is sore from these incidents, which is also articulated in the probable cause declaration. Again, asking for that no contact order. She says he does have problems with drinking almost every day. She also believes that he's using controlled substances, but she wasn't totally sure. She said he believed that he had rifles, but no handguns. So again, based on her statement, the state is asking for those conditions. And I will submit it on that. I do not believe that she wants to speak, but if the court would turn to her at the appropriate time, that would be appreciated.
Sure, Ms. Cook. Oh, hold on, sorry, Mr. Birch. You don't currently have the services of the public defender because you said you were going to hire your own attorney. Is that still the case?
Yes, sir.
Okay, so you've got a choice today. I can't give you the public defender unless you are indigent or you're incompetent or some other extreme circumstance. In this case, it doesn't appear that I have the authority to appoint the public defender. So you could choose to go forward today and represent yourself on this bail matter and then hire your attorney. Or you can request to continue this to allow you to get a private counsel here. What do you want to do?
I'd like to use the public defender.
I can't give you the public defender, so that's not an option. So it's either represent yourself today on this bail hearing or request a continuance so that you can hire your own attorney.
I request a continuance.
Okay, when do you want to come back?
Sometime next week,
Okay, pick a day.
say Thursday, Friday.
All right, we'll see you next Thursday, the 4th at 9:30. Thank you.
Judge, will you order a no contact order right now?
Yeah, so while you're at the jail, sir, don't contact the victim, all right? Or it'll be a new criminal offense. Thank you.
Blue door, sir.
Graney and then Mendez. Graney has 2 matters. We have the new offense. What's the state feels appropriate on that?
Your Honor, the state is asking or seeking $75,000 with no 10% cash alternative based on the Category B offense, child abuse. We're asking for a no contact order with the child victim, along with no firearms or weapons. Do you want the state to address the older case as well?
Sure, you can do both at the same time if you want.
Yes, in addition to that, the state is moving to revoke the defendant's bail on the case ending in 288. And due to the commission of a new felony offense while on pretrial release, pursuant to 178.487, we're asking that his release be revoked and he be held with no bail on that matter. We know the defendant scores a 6 on the risk assessment. However, he does have that pending case in Reno Justice Court, which is for a prohibited person in possession of a firearm. He did have bail set in that matter at $15,000. Looks like he just posted on November 17th. So less than a week, just about a week. And he has committed a new felony offense, been arrested on a new felony offense. Prior to that, he has older criminal history. He was arrested for burglary back in 2012. It looks like it ended up being dismissed. And then he's got a felony conviction for shooting at an inhabited dwelling back in 2007 out of Sacramento, in which he was sentenced to prison on that case. And then he has another felony conviction in 2005 for burglary out of our 2nd Judicial District Court, as well as a gross misdemeanor that same year for conspiracy to commit uttering a forged instrument. Obviously, that older history is very concerning, but this new history, picking up 2 felony offenses in a very short period of time, and while he's on release, is the most concerning for the state as far as our community safety risk. and the injuries to this child from the defendant punching him in the face, essentially. So the state would submit it on those two requests.
All right, thank you. Ms. Cook,
Your Honor, does the court want to arraign him on the other?
you have the
case?
criminal complaint, yes, please.
He has it
That'd be
and
great.
has reviewed it. His name spelled correctly. And Your Honor, his name is spelled correctly at line 7, so we would waive formal reading of that complaint.
All right, and then on that issue, does he want an MSC or a speedy prelim or both?
He most likely is going to revoke the balance.
So speedy prelim, way to go.
Your Honor, he is invoking his right to a speedy preliminary hearing on that matter.
Okay. We'll set that prelim for December 11th at 1:30 and an MSC for December 10th
So I
at 1:30.
We'll see if he revokes for bail.
I've been doing all my court services. I'm laying off heroin now. Can you let me know that?
All right, we can address bail on both cases then if you want to, Ms. Cook.
Thank you, Your Honor. In regards to Mr. Graney's cases, as the state indicated, he did recently post bail on his pending matter. He has been compliant with his check-ins and testing and has also been attending mutual support group meetings since his release. He has been able to remain clean and sober since that release. He was suffering from opiate addiction and is no longer using. Like I mentioned, he has been testing clean and going to meetings in support of that. He does have a residence where he has been residing since August. He also does have employment that we were able to confirm. As the pretrial services report indicates, the alleged victim in the new case is no longer in the residence and is living back with his father in the Somerset area. In addition to that, Child Protective Services through the Human Services Agency is involved. And so there will be an extra layer of support and protection in terms of the family having to comply with whatever conditions that Human Services Agency puts in place in terms of what, if any, contact or visitation is appropriate and how that would occur. We did confirm that he is welcome back in the home. And so what we are asking is, in the new case, is that he be released on his own recognizance with the no contact order, comply with Human Services Agency, and whatever other conditions the court deems appropriate, and that the court not revoke the bail that he was able to post on the prior case, given that he had been checking in and testing clean since his release a couple of weeks ago.
All right, thank you. The state shown by clear and convincing evidence that bail is necessary to ensure the safety of the community and the appearance of the defendant on the new offense that will be set as requested $75,000. He already was on release. He already had conditions set. There's a reason that the legislature passed NRS 178-487. There'll be no contact in this new case, separate criminal offense pursuant to NRS 178-4845 for the maximum 120 days. No firearms, checking with DS's order of bail laws, make all court appearances December 5th at 9:30 is his next court date on that. I do find in the RCR 2025-133-288, based upon the sworn probable cause sheet in the RPC 202564717, that proof is evident, the presumption great, the defendant's committed a felony while on release on the felony, and therefore pursuant to that statute, I will hold him without bail. I will refund his bail in the new case. I'm sorry, in the RCR 2025-133-288 case, so he won't be out Well, he'll be out whatever money he paid the bail bondsman, unfortunately, but his bond's not being revoked. It's being refunded in that case. His new court date, as already indicated in the old case, is the 10th for an MSC and the 11th for prelim. Again, the new case is the 5th for an arraignment. We'll see you back on those dates, sir. Thank you so much. Mendez and then Garza.
No bail right now, right?
That
And there's no way to change that.
But you get refund. It's not revoked, so you don't like this stage. It's not like those one.
I am refunding the bail and holding him without bail pursuant to NRS 178-487. I'm not forfeiting. I am revoking his release and holding him without bail, but I'm not forfeiting the bond.
They don't end up charging. Right. Those are your court dates for that case. And this is your attorney.
For that case. Okay.
And then on the new case, does it have a 10% option?
Yes. All right, what does state feels appropriate on this matter?
Your Honor, state's seeking $50,000 for Mr. Mendez. That's based on the facts of the case. And his very high risk assessment score at 13. You can see he got the maximum number of points for failures to appear within the last 24 months. We know he was just convicted of possession of stolen property in 2024 out of this court. He did fail to appear post-sentence in that case. A bench warrant was issued for his arrest. He was arrested and then the case was closed out. He's got contempt of court arrest in 2023. He's got a conviction for violating a temporary protective order out of Reno Justice Court in 2022. He has a felony conviction for carrying a concealed weapon out of our Second Judicial District Court. He never got released on that case and went straight to prison. He has misdemeanor convictions for domestic battery that same year out of Sparks Municipal Court, possession of drug paraphernalia out of Reno Justice Court. He did pick up a new case while he was on pretrial for that case and he was violated. He has a driving without a valid license in 2021 out of Reno Municipal Court. He failed to appear at the arraignment in that case. He's got a 2016 conviction for possession of marijuana out of Reno Municipal Court, also failed to appear at the arraignment in that case. And then he has misdemeanors for petty larceny, possession of marijuana, trespassing, and more petty larcenies over the years dating back to 2007, most of those out of Reno Municipal Court. So defendant has lengthy history, recent history of possessing stolen items as we see here. So for those reasons, we do believe a higher bail is appropriate and would ask for the $50,000 and we're not seeking any conditions.
All right, thank you. Defense.
Thank you, Your Honor. In regards to Mr. Mendez, he is not able to afford any monetary bail. He has lived in the area for over 20 years. He is currently unhoused. I think the probable cause sheet kind of indicates that he resides sometimes in a trailer at his father-in-law's address and has also stayed at the CARES campus off and on. He currently is supporting himself through assistance from his mother, who does live in town, and doing side jobs. He does have a potential employment prospect with Burger King, where he's supposed to go on Monday to follow up with that. He indicated that he does not have his phone number memorized, but he does have a text now number. That phone is in his property here at the jail, so he would have access to that were he to be released from custody, to receive court reminders and any other information in regards to check-ins. He also does have an email address that he checks regularly as well to maintain contact. So what we are asking due to Mr. Mendez's inability to afford monetary bail is for him to be released on his own recognizance. I think it's interesting that there is question about the ownership of the van at issue. That law enforcement was also not able to confirm. And so I think unless and until that is confirmed, there could be validity to Mr. Mendez's version of events, at least in regard to the van itself. So with that, we are asking that he be released on his own recognizance.
All right, thank you. The state shown by clear and convincing evidence that bail is necessary to ensure the safety of the community and occurrence in the defendant, and have not been provided any least restrictive means that will mitigate those risks. Therefore, the bail will be set as requested, $50,000, no contact. Bail laws may go court appearances December 5th at 9:30 is the defendant's next court date. We'll see you back then. Garza. And then Lester.
If you can post that bail. It's done on the other side. Yeah, with bail. We could do, it would be either $5,000 cash or something to the jail. A bail bonds person usually takes off 15%, so it's about 700.
There's no way to go.
So you can post them. 12 this year. Depends on what happens with your needs, but the charge me at high side still or whether you fight it or don't fight it.
So I was in that bad, it's the first to be whatever it is. Did you approve? So it's no.
All right, what does the state feel is appropriate?
Your Honor, based on her lower risk assessment score as well as no criminal history, the state's not going to object to an own recognizance release. We are, however, based on the facts of the case, asking for a pretrial supervision, which would include a no alcohol and daily alcohol testing as part of that pretrial supervision.
All right, defendant's released on her own recognizance. Daily alcohol testing, random drug testing, DUI rant and cars, DAS supervision, obey laws, make all court appearances. You'll need to be here next Thursday for your arraignment, but you need to check in with us by the end of Monday at the Reno Justice Court, 1 South Sierra Street before 5 p.m. Be here to make sure we have your good contact information so that we can send you court reminders. All right.
Thank you.
Thank you.
What date was that arraignment, Your Honor? Sorry.
Next Thursday, but we'll give it to her again when she comes in Monday, as long as she just comes in Monday by 5 p.m. We'll make sure we have good numbers to text her so we can always give her the court dates.
Thank you, Your Honor. Thank you.
And then that gives you time to hire your own attorney too, Ms. Garza. You said you were going to hire your own attorney.
Thank you.
Thank you. Lester.
Garza.
And then we'll go back to Lazaro Guerrero.
Yeah.
Morning, Your
Good
Honor.
morning. What is the state feel appropriate on this matter?
Your Honor, state seeking $10,000 bail on this matter. That is based on the defendant's high risk assessment of 12. He has a fairly lengthy criminal history of criminal history and non-compliance. We know that this happened back in August. He was on a parole violation on his way to prison, basically. We know that since he's been released from that, and that is associated to a 2023 battery with a deadly weapon conviction out of our Second Judicial District Court. Since he's been out on that case, he was convicted of pedestrian under the influence of alcohol. That was out of Sparks Justice Court earlier this year. He was OR'd and he never complied with pretrial services in that case. He ended up pleading and got credit time served once he was picked up on a warrant. It looks like he also was convicted just in October of defrauding a proprietor out of Reno Municipal Court. He got a 30-day suspended sentence on that case. That's still in effect right now. Obviously, this case is older than that, but he has picked up those 2 new misdemeanors. In addition to that, he has older history, some misdemeanor convictions for obstructing and resisting and stolen property and carrying a concealed weapon. And then he just has numerous failure to appear arrests in 2021, 2022 on different misdemeanor cases. So we do believe the defendant poses a flight risk based on his continued criminal activity and failures to appear. So the state believes that $10,000 is appropriate. We're not seeking any conditions.
All right, thank you. Defense?
Thank you, Your Honor. And speaking with Mr. Lester, he is not able to afford any monetary bail. He has lived in Reno for his entire life. He is currently living at the CARES campus and has been there for the past 2 months. He does have temporary work through Elwood Staffing. He does have family here in Reno. Both his mother and grandmother reside here as well. As the state indicated, this was an older incident that did occur while he was in custody here at the Washoe County Jail. I understand that he does have a history of failing to appear. But I think that if he does have some sort of check-ins and gets court reminders, he would be much more likely to appear at his future court dates, which I know that Reno Justice Court will ensure that he is receiving. So we would ask that he be released on his own recognizance on this case. Again, given that it is an older allegation for conduct occurring here in the Washoe County Jail, that perhaps one way to decrease recidivism for Mr. Lester is if he is not confined here in detention.
All right, thank you. Let's go ahead and arraign him also. Do you have a copy of the complaint?
He does, as I said.
Yes.
And his name is correctly spelled at line 7. He has reviewed it and would waive formal reading.
All right, thank you. Does he want a speedy prelim or an MSC or both?
Your Honor, he would like to invoke a speedy prelim.
Okay. Second, we see how we're doing. All right, we'll set it for December 11th at 1:30 for the prelim. The MSC will be December 9th. Both of those are at 1:30. And I'll relieve the bail as set. The state has shown by clear and convincing evidence that bail is necessary to ensure the safety of the community and the appearance of the defendant. And I've not received any mitigated circumstance, least restrictive means that will mitigate that risk. And so we'll see you back at your MSC on the 9th, sir, at 1:30. Thank you.
Thank you, Your
All
Honor.
right, that leaves our final matter, Lucero Guerrero.
Lázaro Guerrero.
For $500.
What does the state feels appropriate?
Your Honor, we are seeking bail in the amount of $20,000
Su señoría, estamos pidiendo una fianza en un total de $20,000
with DAS supervision,
con supervisión de AS,
along with a no contact order with the minor pursuant to court order as well as per statute for 120 days.
También vamos a pedir una orden de no contacto con el menor, de acuerdo también a lo del juzgado. Van a ser 120 días.
That bail reflects the defendant's community safety risk based on his conduct in this case.
Eso va a reflejar entonces el riesgo de la seguridad de la comunidad en este caso.
We did speak with the victim's mother, who I believe is on the Zoom here today.
Hablamos con la madre de la víctima, que creo que está aquí por Zoom hoy día.
She is asking for that no contact order with her daughter.
Ella está pidiendo esa orden de no contacto con su hija.
Um, it's a complicated situation because her daughter is in love with the defendant.
Es una situación complicada porque la hija de ella está enamorada del acusado.
She said she does not have safety concerns,
Ella dice que no le preocupa la seguridad,
but obviously she does not approve of the relationship.
pero obviamente ella no aprueba esa relación.
So based on the facts of the case, he does have a prior domestic battery arrest in 2021.
Bueno, basándose en los hechos del caso, además que él tiene antecedentes de un caso de violencia intrafamiliar en el 2021
out of Las Vegas, but it doesn't show what the final disposition was.
en Las Vegas, pero no muestra cuál fue la consecuencia final de ello.
But based on the nature of the offense, the state believes that $20,000 and conditions are appropriate.
Basándose en ello, la fiscalía cree que los $20,000 y las condiciones son apropiadas.
All right, thank you, defense.
¿Qué gracias a la defensa?
Your Honor, in Mr. Lazaro's case, he is only able to afford $1,500.
Su señoría, al señor Lázaro solamente podría pagar $1,500.
We were able to confirm that Mr. Lazaro has resided in Reno for 4 years.
Nosotros pudimos confirmar que el señor Lázaro ha residido aquí en Reno por los últimos 4 años.
We were able to verify his address
Pudimos verificar su domicilio,
as well as his phone number.
también el número de teléfono de él,
And we were also able to verify his employment.
y también pudimos verificar su empleo.
His roommate indicated that Mr. Lazaro Guerrero is a good person as well as a hard worker.
El compañero de cuarto del señor Lázaro dijo que él era era muy trabajador, que también era una muy buena persona.
And the roommate also verified that there are no children who reside in the home.
Y el compañero de cuarto también verificó de que no hay niños menores de edad en la casa.
Your Honor, given the information that we were able to confirm, Mr. Lazaro would only score points for this being his first arrest.
Señoría, debido a que hemos podido verificar la información y estos puntos que él ha acumulado son solamente por su primer arresto,
As was explained by the state, this is a complicated situation of a relationship between the alleged victim and Mr. Lazaro.
como lo explicó la fiscalía, esto es una situación complicada basándose en la relación de la presunta víctima y el señor Lázaro.
So given the nature of that situation, I believe that any risk could be mitigated through a no contact order with the alleged victim.
Dada la naturaleza de esta situación, yo creo que cualquier riesgo entonces podría ser evitado dando una orden de no contacto con la presunta víctima.
And given his very limited criminal history, I don't believe that there are any other conditions necessary in his case.
Basándose entonces, dado en los antecedentes penales muy limitados que tiene el señor, no creo que sean necesarias más condiciones en el caso de él.
All right, thank you. You set the bail at $10,000 or 10% cash, no contact, separate criminal offense pursuant to NRS 1784845 for the maximum 120 days. Ankle monitor in place before release to ensure compliance. DAS supervision of bail laws make all court appearances December 5th at 9:30 is the defendant's next court date.
I'm sorry, Your Honor, the interpreter missed the date, December 7th.
Oh, I'm so sorry I went so fast. I forgot about you. December 5th at 9:30.
Ok, vamos a fijar la fianza entonces en un total de $10,000 con el 10% que tendría que tener dinero en efectivo. Hay una orden de no contacto de acuerdo a la ley vigente 178.444, un máximo de 120 días. Si llega a ser que él sale, entonces va a tener que tener un monitoreo electrónico, mantenerse fuera de problemas. Su próxima audiencia será para el 5 de diciembre a las 9:30. Gracias.
La puerta azul.
All right, is that everybody up to jail?
That's it, Your Honor.
Thank you.
All right, have a great Thanksgiving, everybody. Thank you.
Thank you, you too.
Bye.